Welcome back to our drafting class on deeds. In the previous video, we discussed deed as to relevance, that is applicability, deed as to purpose, referring to the function, deed as to validity. And we mentioned that whether a document or transaction should be evidenced by way of deed is a question of law, and that for a deed to be treated as valid, it must have been signed, sealed, and delivered by the parties involved in the transaction. Also, the functions of a deed is married to the specific example of deed. In this video, we want to discuss deed as to structure. Deed as a structure. So let me read a definition once again. A deed is a legal document with a fixed drafting structure that must be signed, sealed, and delivered by the parties involved in any transaction where the law requires it. Pay attention to that phrase, with a fixed drafting structure. So don't forget that we're talking about a legal document, and you, as a solicitor representing the parties to these property law transactions where the document to evidence it must be by way of deed, you must realize that there is a prescribed format that you must follow when preparing such a document. So, where, for example, in a gift inter vivos, right, the deed of gift has a prescribed format that you must follow. So you cannot just draft a deed of assignment just anyhow or the way you feel. Okay, I just feel that this is my own style. No, you don't have your own style. There is a fixed drafting structure that you must follow. Now, because I know the various examples of deeds and how to draft each of them, I can tell you categorically that following these prescribed formats would make whatever whichever deed you want to draft, when you follow this prescribed format, the first thing that you would end up achieving is that it will make that particular deed, let's say a deed of assignment now, it will make it very tidy and easy to read. Why? Because the fact of what has transpired between the parties, that is between the assignor and the assignee, that was involved in that sale of land transaction, for instance, will be sequentially arranged. So anybody can easily pick it up, that deed of assignment, and then to be easy to understand, because you have been able to arrange the facts leading to the transaction in a sequential order by following this prescribed format. Also, this prescribed format has details that is expected of you as a solicitor to ensure that you fill in. That is, you must ensure that these details are included in that particular deed. So the moment you follow this drafting structure, right, you won't leave out certain information or create any form of ambiguity, which the prayer of a draftman is that whatever a draftman prepares must not be ambiguous, and that you must not leave certain informations out. So, what a layman may not be looking at when it comes to a sale of land transaction, because you are the solicitor who wants to act for the assignee to prepare that deed of assignment, there are certain information you know that you must ask from your client, and you must ask from the assigner certain details, right? Say, okay, what's the dimension of the land? The assignee, probably being an illiterate, it might not necessarily see the importance of those information, but because you know that the reason why a deed follows a structure is that every information necessary to give force of authenticity, legitimacy, and validity to that document, you know those informations to what elicit from the parties. Also, the moment you have been able to achieve this fixed drafting structure of a deed, it becomes easily enforceable. Why? Because whatever has transpired between the parties, their deed of assignment or deed of gift or lease or deed of legal mortgage or deed of sublease, whichever transaction it is, you have correctly reflected the things that has transpired between the parties. So now that you have begun to appreciate the essence of following this prescribed format, let us now mention facts about the structures of a deed. So take note that a deed is divided into 4 parts. So that legal document, that is that deed of assignment, deed of gift, that power of attorney, is divided into 4 parts. So if you see it in your MCQ, now you know that the answer is that every example of deed has 4 parts. Furthermore, note that each part is then further divided into clauses, and that each clause has its own function. So, for example, your head is a part of the structure of your body, but within the same head, you have clauses. What are those clauses? Your eyes, your nose, your ear, your tongue, your mouth. And then each of these clauses we have mentioned, they have their own what? Function. That's despite the general purpose of the human head. So that means that in this video, we would have to talk about each part. We would have to list the clauses found in each part of a deed. And then, of course, we would have to discuss the function of each clause. And then finally, we would have to learn how to draft that particular part as well as the clause. So please, you take note of that. So let's start. What are the 4 parts of every deed? Every deed is divided into 4 parts, and these parts includes 1. Introductory part, 2. Operative part, 3. Miscellaneous part, and 4. Concluding part. Every deed is divided into how many parts? 4. What are the 4 parts of a deed? Number 1, introductory part, operative part, miscellaneous part, concluding part. We're going to go again for the last time. 1, we have the introductory part, operative part, miscellaneous part, and the concluding part. Please take note of these cautions now. First, I did not just say introductory, operative, miscellaneous, concluding. Ensure you write parts if it's a theory question. If it's an MCQ, you have no control over that. But the moment it's a theory question, if you are asked to list the parts of a deed of assignment, introductory part, you write it in full. Operative part, miscellaneous part, concluding part. Also, take note that we did not say introduction part. We said introductory part. We did not say operation part. We said operative part. And we did not say conclusion. We said concluding part. You may be wondering, why is he stressing us about whether it's introduction? If you have solved some of your MCQ, some of the tricks of the examiner is to ask you what are the parts of a deed of assignment. Then you will see introduction. You will see introductory. If you are not certain that it is introductory, you might be tempted to pick introduction, thinking that, I almost got it. When it comes to MCQ, there's nothing like I almost got it. So you must know it that a deed is divided into introductory part, operative part, miscellaneous part, and concluding part. So, the various examples of deeds that we have: power of attorney, deed of assignment, lease, deed of sublease, deed of legal mortgage, deed of rectification, right? Deed of revocation, and many others. They are divided into how many parts? 4 parts. And what are these 4 parts? Introductory part, operative part, miscellaneous part, and what? Concluding parts. Now, our focus is deed of assignment, and of course, we are following the syllabus, right? So our focus is to discuss deed of assignment. So let's ask a few questions about deed of assignment. Our first question is: a deed of assignment is used in which property law transaction? Now, based on our explanation so far, you can confidently say it is used in a sale of land transaction. So I'm going to ask 3 more questions, and I want you to supply the answers in the comment section. Second question is: a deed of assignment is divided into how many parts? The third question: each part is made up of. Then the last question is: A deed of assignment is a type of deed known as what? So please put the answers in the comment section. So now we want to move into this listing out the parts and clauses of a deed of assignment. So if somebody were to wake you up in the middle of the night and then asked you, how many parts do we have in the deed of assignment? You are going to tell the person 4 parts. Then it goes further to ask you, mention those parts. You are going to say you have the introductory part, the operative part, the miscellaneous part, and the concluding part. Then because each of these parts have their various clauses, it then further asks you to list the clauses found under each of these parts. So that is what we're going to do now. We're going to list out the clauses found in each of the parts of a deed of assignment. In the subsequent videos, we will now focus on each part, talk about the clauses, the function of that clause, and then offer a sample draft, so that whichever perspective the examiner is coming from, either the examiner just wants you to list, the examiner wants you to draft, the examiner wants you to state the function, you are home and dry, and you'll be able to do well in that question. So let's look at the introductory part of a deed of assignment. What are the clauses in the introductory part of a deed of assignment? 1, we have commencement. 2, dates. 3, parties. 4, recitals. We're going to take it all over again so that you will remember. You don't have to memorize this as though you are cramming, right? I want it to be that after watching this video, if tomorrow is your bar final examination, you'll be able to list out the introductory part of deed of assignment. So I want you to take the video very, very seriously. So the first one is what? Commencement, date, parties, recitals. We're going to go again. Commencement, date, parties, recitals. Commencement, date, parties, recitals. Commencement, date, parties, recitals. Commencement, date, parties, recitals. For the last time, commencement, date, parties, and you have what? Recitals. So if the question says list the introductory part of a deed of assignment, what's your number 1? Commencement. Followed by what? Date. Followed by parties, and followed by recitals. In case you are wondering, why are we particular about this particular order? The reason is that for the subsequent ones we're also going to see, you have to follow this correct order when listing your answers. So there's nothing like, oh, I remember the introductory part of a deed. Oh, I remember parties, and you put number 1 parties. They say, oh, I can't remember. Okay, I think something commencement. Then you put number 2 commencement. You'll be marked wrong. And then you have to say, no, now I tried. The examiner will ask you, if somebody told you that somebody has given birth to a child, and they said, okay, go and visit the child, and then you finally get there, you now discover that the eyes of the child is in the stomach, the leg is on the head. Won't you run away? I'm very sure that you will run away. That's the same way too. The examiner too is scared, is afraid, because you are not following the structure as it is. There is a structure. So sometimes, and many times, if you look at your past questions, you will see questions like list in the correct order. So if you miss just one, that you have missed the entire mark for that particular question, asking you to list out the parts or clauses in that particular, let's say the operative part or the introductory part. Missing one is missing all. You must follow everything. It's like domino. Once you release one, everything falls. That's the same way this works too. So that's where we are particularly saying commencement, date, parties, and recitals. So if you were to close your eyes and somebody were to ask you, recite the introductory part of a deed, after while closing your eyes, then you say commencement, date, parties, recitals. If I were you, I'll pause this video, bring out the sheet of paper, and write it like 5 times. Commencement, date, parties, recitals. Just write it. It might not make sense now, but when it's time for your bar finals examination, you are coming back to say thank you, sir. Now let's look at the operative part. The operative part of a deed of assignment. The operative part of a deed of assignment. What are the clauses found under the operative part of a deed of assignment? We have the testatum, consideration clause, receipt clause, capacity clause, word of grant, all that clause, parcel clause, and you have the addendum. So there are 8 clauses under the operative part of a deed of assignment. And of course, we are going to painstakingly take these 8 points again and again so that at least it can help us retain the clauses in our memory, right? So let's go again. What are the clauses in the operative part of a deed of assignment? Number 1, you have the testatum, consideration clause, receipt clause, capacity clause, word of grant, all that clause, parcel clause, and addendum. We're going to go again because we must know it. We are not guessing. In the bar finance, there's no opportunity to guess. It's either you know it or you don't know it. So let's take it again. 1 to go. Testatum, consideration clause, receipt clause, capacity clause, word of grant, order clause, parcel clause, addendum. We'll go again. Bar finance is not here tomorrow, so we still have time now. Once again, testatum, consideration clause, receipt clause, capacity clause, word of grant, order clause, parcel clause, addendum. Please close your eyes as we say it for the last time. Just try to close your eyes. Yes. Testatum, consideration clause, receipt clause, capacity clause, word of grant, order clause, parcel clause, addendum. Once again, pause the video. Write this out 5 times. Write it out 5 times. I'm still going to tell you when you're going to start using all these things you're writing 5 times. There's when you will now use it. Then you now later appreciate why you have written them 5 times. So please ensure you do that. Pause the video. It's not going anywhere. You are going to watch the next part, which is we're talking about the miscellaneous part of a deed of assignment. But as an hint, you know that the introductory part has 4, the operative part has 8, right? And you must list them in the correct order. The next part of a deed of assignment is miscellaneous part. What are the clauses in the miscellaneous part? You have what is known as indemnity clause. 2, acknowledgement for production and undertaking for safe custody. So now see, this one is very simple. See, it's just 2, of course, and you have 2 hands, so you must remember this one. So the first one is what? Indemnity clause. The second one is what? Acknowledgement for production and undertaking for safe custody. How many clauses do we have in the miscellaneous part? In the deed of assignment, we have the indemnity clause, the acknowledgement for production and undertaking for safe custody. Once again, we have the indemnity clause, we have the acknowledgement for production and undertaking for safe custody. We have the indemnity clause, the acknowledgement for production and undertaking for safe custody. So these are the clauses in the miscellaneous part. Let's go to the concluding part of a deed of assignment. So for the concluding part of a deed of assignment, we have the following clauses: testimonium, schedule, execution clause, attestation clause, and franking. So what are the clauses in the concluding part of a deed of assignment? We have the testimonium, schedule, execution clause, attestation clause, and franking. Let's go again. We have the testimonium, we have the schedule, we have the execution clause, we have the attestation clause, and we have the franking. For the last time, close your eyes. The testimonium, the schedule, the execution clause, the attestation clause, and franking. So you have to pause again, write it out 5 times. Just repeat it so that your hand can be familiar with whatever you are writing. That when you are in the bar finals, you are not trying to second guess. You know that this is the answer. Testimonium, schedule, execution clause, attestation clause, and franking. Now that we have seen it according to the parts, introductory part, operative part, miscellaneous part, concluding part, let's now list out all the clauses. In case you are now asked, this time around, the examiner is not asking you to list it based on the parts. The examiner is simply saying, list out the clauses in a deed of assignment. Then you will now want to list out everything. So let me see if you can get the first 4. So what we're going to do is this. You know that, of course, don't refresh it on paper. Try to write the first 4. See if you can remember it. The first 4. So I'm going to count 1 to 10. Don't write yet. I'm going to count 1 to 10. Or let me give you 1 to 20. I think that was too much. Let me give you 1 to 15. So I'll count from 15, 14, right? So but ensure, don't write yet though. So ensure you can write the first 5. Let's see if you can remember the first 5 without looking at your notes. Let's start. 14, 13, 12, 11, 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. So mark yourself. How many were you able to remember? Were you able to remember at least 4 out of 5? The first 4. So let's list out all these clauses one after the other now. It's the same thing, but this time around, we are not putting operative part, miscellaneous part. We want to list it out in case that is what the examiner wants from you. So what are these clauses? The same thing, but this time around, just listing them out. Commencement, date, parties, recitals, testatum, consideration clause, receipt clause, capacity clause, word of grant, all that clause, parcel clause, addendum, indemnity clause, acknowledgement for production and undertaking for safe custody, testimonium, schedule, execution clause, attestation clause, and franking. So here you see you have 19 in total. In case you are wondering if you can remember, see, I can guarantee you will remember. Just follow what I have asked you to do. You are going to remember. In the day of your bar finals, you won't forget because you've taken out time to learn it. You've recited it. You've handwritten it. Your brain is getting familiar with whatever you are writing. On the day of the bar finals, you are definitely going to remember that you have the commencement, you have the date, you have the parties, you have the recitals, you have the testatum, you have the consideration clause, the receipt clause, capacity clause, word of grant, order clause, parcel clause, addendum, indemnity clause, acknowledgement for production and undertaking for safe custody, testimonium, schedule, execution clause, attestation clause, and franking. What we're going to now start to do in the subsequent videos now, which is the next video, is that we want to now pick each of these part of a deed, the introductory part, operative part, miscellaneous part, and concluding part. Then we'll talk about each of them. We'll talk about the clauses once again, but this time around, I will tell you the meaning and then the function of that clause. Then we offer a sample draft. But I'm going to do something very beautiful for you. I'm going to give you a scenario. So we are going to work with that scenario to analyze all these introductory parts and the clauses, the operative part and the clauses, the miscellaneous part and the clauses, and the concluding part as well as the clauses. So please ensure that you watch the next video.